Can a police officer force you to show your firearms in the United States, or enter your home and demand to inspect them? This is one of those questions that sounds simple, but in real life it sits in a very complex area of constitutional law, police procedure, and practical behavior during encounters. And the most important thing to understand right from the beginning is this: in the United States, your rights do not disappear just because you are being questioned by law enforcement. But at the same time, those rights also depend heavily on context, situation, and how you respond in the moment. So instead of guessing or relying on social media myths, we are going to break this down in a realistic, structured way using two of the most common scenarios people actually face. One is when law enforcement shows up at your home. The second is when you are stopped in your vehicle during a traffic stop. Let's start with the home situation first, because legally speaking, your home has the highest level of protection under the United States Constitution. Imagine you are at home and there is a knock at your door. You look outside and see law enforcement officers, and in some cases it could even be federal agents such as ATF. They tell you they are there to confirm firearm ownership or verify records of weapons purchased under your name. They may speak in a calm tone, they may present it as a routine check, or they may imply urgency or legal necessity. At this moment, many people feel immediate pressure to cooperate. But legally, cooperation is not the same as obligation. Under the Fourth Amendment of the United States Constitution, individuals are protected from unreasonable searches and seizures. That protection is especially strong when it comes to your home. In fact, in American law, the home is considered one of the most protected spaces in terms of privacy rights. What that means in practical terms is simple: law enforcement cannot legally enter your home or search your property without proper legal authority. That legal authority generally comes in three forms. First, a valid search warrant issued by a judge based on probable cause. Second, a valid arrest warrant in situations where entry is legally justified. And third, a very limited category known as exigent circumstances, which involves emergency situations where immediate action is necessary to prevent harm, destruction of evidence, or an ongoing crime. Outside of those conditions, entry into your home is not automatic. And this is where the concept of voluntary interaction becomes very important. When officers knock on your door without a warrant and begin asking questions, that interaction is often referred to as a knock and talk. It is not a legal entry. It is not a forced inspection. It is essentially a request for voluntary cooperation. And voluntary means exactly that. You are not legally required to open the door. You are not legally required to answer questions. And you are not legally required to allow them inside your home. This is where many misunderstandings begin. People assume that because someone in uniform is at the door, there is an automatic legal obligation to comply. But in reality, unless there is a warrant or legal exception, you still retain your full constitutional protections. Now there is another layer to this discussion that often creates confusion, especially when firearms are involved. Some people believe that owning firearms, particularly those regulated under federal law, reduces your privacy rights or gives law enforcement broader access to your property. That is not how the law works. Even if a person owns firearms regulated under federal categories such as the National Firearms Act, including items like suppressors, short-barreled rifles, or other regulated weapons, that ownership does not automatically eliminate constitutional protections. Owning a firearm does not equal surrendering your Fourth Amendment rights. It does not give law enforcement automatic permission to enter your home or inspect your property. However, there is a very important distinction that must be understood clearly. If law enforcement does have a valid warrant, then the situation changes completely. At that point, they are no longer requesting permission. They already have legal authorization granted by a judge, and the entry becomes lawful regardless of consent. So the entire home scenario comes down to one core principle: without legal authority, entry is not mandatory, and interaction remains voluntary. Now let's move to a situation that is far more common for most people in everyday life, and that is a traffic stop. You are driving on the road. You get pulled over by a police officer. The officer approaches your vehicle, and after the initial interaction, they may begin asking questions. In some cases, they may ask if there are any weapons in the car. In other cases, they may request to search the vehicle entirely. This is where many legal misunderstandings happen because traffic stops are fast, stressful, and emotionally charged situations. The first thing to understand is that your behavior during a traffic stop is extremely important, not only legally but practically. The way you act can influence how the officer interprets the situation. The most important rule in any traffic stop is to remain calm. Keep your hands visible at all times. Typically, this means placing them on the steering wheel where the officer can clearly see them. Avoid sudden movements, avoid reaching into unknown areas of the car, and avoid actions that could be misinterpreted. When asked for documents, you are generally required to provide basic driving credentials such as your driver's license, proof of insurance, and in some cases vehicle registration depending on state law. Beyond that, you are not obligated to volunteer additional personal information. During this interaction, officers may begin asking questions that are not strictly required by law. These questions might be conversational, investigative, or even indirectly pressuring you to respond. However, legally speaking, you still have the right to remain silent. That right is part of the Fifth Amendment protection against self-incrimination. In practical terms, this means you are not required to answer every question asked during a traffic stop. You can choose to limit your responses, and in many cases, that is a legally protected choice. If you decide to exercise that right, it is often best to clearly and calmly state that you are choosing not to answer questions, rather than arguing or refusing aggressively. Another critical right during a traffic stop is the right to refuse consent to a search. If an officer asks to search your vehicle, you are generally allowed to say no. However, that refusal must be clear. Silence or hesitation can sometimes be interpreted in different ways depending on the situation and jurisdiction. A clear verbal statement is typically the strongest way to establish refusal. However, even if consent is refused, officers may still proceed in certain situations if they believe there is legal justification. That justification may come from probable cause, visible evidence, or safety concerns. One of the most common reasons officers escalate situations during traffic stops is based on perceived behavior. Sudden movements, reaching under seats, or nervous gestures can sometimes be interpreted as suspicious or unsafe behavior. This is often referred to in law enforcement terms as furtive movement behavior. Whether or not the interpretation is correct, it can influence how the officer proceeds. That is why controlled, calm, and minimal movement is extremely important during any traffic stop. If an officer issues a ticket, in most situations the best response is simply to accept it calmly. Arguing on the roadside rarely changes the outcome and often increases tension unnecessarily. Legal arguments are better handled in court rather than on the side of the road. During the stop, officers may also ask questions in a way that is designed to encourage immediate answers or create pressure. This can include assumptions or statements framed as facts, such as implying you were speeding or already violating the law. Even in these situations, you still retain the right to remain silent. You are not legally required to confirm or deny accusations on the spot. It is also important to understand that refusing consent to a search is not an admission of guilt. Legally, it is simply an exercise of a constitutional right. However, officers may sometimes attempt to persuade you otherwise using conversational pressure or logical framing, such as suggesting that innocent people should have nothing to hide. Despite that, the legal protection remains the same. If the officer requests that you step out of the vehicle, in most cases they are legally allowed to make that request. From a practical standpoint, complying is usually safer and reduces escalation risk. But again, compliance does not mean surrendering all rights. You can still remain silent, and you can still refuse consent to searches unless there is proper legal authority. Now if the situation escalates further and the officer tells you that you are not free to leave, the situation has shifted from a voluntary stop into a detention. At that point, it becomes important to ask a direct question, whether you are free to go. If the answer is no, then you should understand that you are being detained under legal authority. In that situation, your rights become even more important. You should clearly state that you are exercising your right to remain silent. And you should also request legal counsel. This is part of your Sixth Amendment right, which guarantees access to an attorney. One important mistake many people make is waiting for Miranda rights to be read before requesting a lawyer. In reality, Miranda warnings are only required under specific interrogation conditions, and they are not always read during traffic stops or initial encounters. That is why clearly requesting legal counsel is the safest and most protective step if the situation escalates. When we bring everything together, the legal structure becomes clearer. Law enforcement does not have unlimited authority to search your home or inspect your firearms. Your home remains highly protected under constitutional law. During traffic stops, you retain the right to remain silent, the right to refuse consent to searches, and the right to request legal counsel if detained. However, law alone is not the only factor that matters. Behavior, communication, and situational awareness all play a major role in how these encounters unfold in real time. Understanding your rights is not about confrontation. It is about awareness, control, and knowing where the legal boundaries actually exist. Because when you understand the law properly, you are not only protecting your rights, you are also making smarter decisions in high-pressure situations.